Good afternoon. I'm your host, Brian Buckmeyer, here at Justice and Peace. Let's start off with something the Washington Post came out with just recently, detailing the actions that happened to some of the protesters. Now, you've seen the protest for George Floyd, probably in your own state, in the country, and also internationally. But some of those who protested peacefully lost a lot more than you would think. Some of them have lost their vision in one way, shape, or form due to the use of non-lethal projectiles. I'm talking about beanbags, rubber bullets, gas canisters. Now, part of the issue that the Washington Post found out is the recount of how these incidents occurred by the police seemed to be a little off when you look at the video. Let's start off with what the Washington Post came out with in talking about this issue.
The Post found that during 6 days of unrest, from May 28th to June 2nd, at least 12 people lost vision in one eye after being struck by police munitions. 8 of those injuries occurred on just one day, Saturday, May 30th, in states from California to Ohio. 6 of the injured were men and 2 were women. They were hit with what are called less lethal weapons, beanbag rounds, pepper balls, and in one case, a gas canister.
So I squeezed my eyes shut and started yelling, "I'm pressed, I'm pressed."
I never thought I was going to go to a protest and lose an eye.
Whatever did just happen is catastrophic.
When he hit me, I just noticed the blood just coming out.
Something like a fire had exploded in my face.
And they had turned around that corner, and then all of a sudden I was struck in the eye.
It was like I was burning up, I'm being burnt alive.
The pain, my eye was like the size of a softball at that time.
Most of the police departments and law enforcement agencies involved said the incidents are under investigation. Several said projectiles were fired because rocks or other objects had been thrown at officers. Others said it was because crowds refused to disperse. The Post interviewed witnesses and reviewed 911 calls.
He's bleeding a lot and it hit his left eye.
Police reports, cell phone and surveillance video. In 3 cases where we obtained extensive images and video, those who were injured posed no obvious threat to the police. In each instance, video appears to undermine official accounts of the incident.
So I'm joined by defense attorney Joe Richardson. Joe, we're looking at some of these events. This was a great piece put out by the Washington Post. It really broke it down for us. And it seems like and I want to use a proper word, the arsenal that the police force are using are things at times, even though they're non-lethal, they wouldn't kill you. But you look at some of these rounds of rubber bullets, this is not what you and I maybe used to use when we were kids with little pellet guns or BB guns. These things are massive, and you would assume that you would have some serious injuries when these are shot at you. I mean, you can see the size of these bullets compared to people's hands. You take this to the face, and you're bound to lose an eye. What are your thoughts about how the munitions that are being used, or the arsenal that's being used, and should this be in the hands of the police force?
You've got a couple things that are going on here. Once again, first of all, you've got the fact that these things are being used that are, while not lethal, to your point, are dangerous enough where they can inflict serious bodily harm. And in this case, we've got folks losing their sight, which is fundamentally life-changing. Most of us get 70 to 80% of our information from our sight. A lot of these folks lost the use of at least one eye. Then you've got whether or not, aside from whether or not this should be done at all, whether or not we have a basis of truth about what actually happened. The investigation showed that in several of these instances, the police report was very different. The police report apparently had the goal of creating a reasonable amount of fear of harm to justify the use of this non-lethal but very, very dangerous and damage inflicting instrument. So again, there's one thing to have a discussion about whether or not this should happen at all. I would argue that it shouldn't because, among other things, one of them was a journalist most of these people were protesters. Statistically speaking, they were probably peaceful protesters. The other thing is now I can't even listen to the police officers or to the police and get the truth about why what happened. And so now what do? Do we have a discussion now about, oh, well, okay, the police lied about what actually happened. So now that we know the truth of what's happened, now let's evaluate who's right and who's wrong. It shouldn't be about who's right and who's wrong. Protesters have a right to be protected because the Constitution protects them in the first instance. The Constitution should not be thrown out the window because the police are insecure about and fear-laden about what's happening out here on the street in reaction to the killing of George Floyd. So there's many points here, many stopgaps where the police can do the right thing. They can not kill George Floyd. They can tell the truth about why they're doing what they're doing, but they can also have a larger discussion, and I think the people are forcing that, about what they ought to be using and under what circumstances. And so we've got a lot of problems here at a lot of levels. It's just a shame that these people were protesting or reporting, bringing people news, helping to present truth, which the police in this instance were not doing, and now they're punished for it for life.
Agreed. And I know we talk a lot about on this show and just generally when we're talking about police reform about transparency, but just because we can see the harm being done, like you telling us, or we can see it on video, we actually need action after the fact, because there's transparency, then there's misrepresentation. And so when we see it as misrepresentation, the question becomes, well, what's on the back end? Joe, I know you and I can go on this for days and days, but I know that you have spoken to your own residential expert for our next story. So let's switch gears and let's talk about a story out of Michigan that, as jaded as I am and as many stories that I've heard in my own profession through my own work and my colleagues, this one made my jaw drop. When I heard about a Michigan teen, a 15-year-old, who was in a juvenile facility, a juvenile correction program, where she's on probation and she's, quote unquote, violates probation because she did not complete her homework, when the school went from, like every other student in this country and many across the world, went from physical to virtual. And because of that, she is now sitting in jail, or in a juvenile facility. And the next hearing date is September 8th because of not completing homework. Joe, I want to come to you because you've got a lot to talk about in this. Break it down for us, please.
Well, I'll tell you what I saw, and then I'll tell you what the resident expert saw. My wife is a speech therapist, which is part of special education. So, because teamwork makes the dream work, I said, look at this and tell me what you see. What I see is, and it's not invalid, overly punitive criminal justice system. I see a Black child of color inside a largely white system. And I see someone being thrown in jail when, because of COVID, you're trying to keep people out of jail, particularly people that are nonviolent. Now, this child got into it with her mom, and that's why they're on probation. But I think she bit her mom's finger, okay? Her mom made it from that, all right? So once my wife looked at it as a person that does special education, this is what she saw. There's an IEP, which means individualized education program, because this child has special needs. There's a situation where this child has largely been compliant with what it is that's supposed to be happening related to her probation, related to her study. We also have a situation where she's not in touch most of the time with her special education teacher. So for a long time, the special education teacher wasn't even involved like they needed to be. Right now, guys, nobody's following all the rules because they can't on some level. And then the whole prosecution in terms of the probation violation was because the mom made a comment, admittedly in frustration. The child's not doing what they're supposed to do, that kind of thing. And then once you get to the probation hearing, the only witness is the caseworker, who acknowledged on cross-examination that they couldn't even tell you what this child actually needs per their IEP. So you've got this child being failed on just about every level, when every other trend says if a child's nonviolent, you do everything that you can to keep them out of the system. Particularly right now, you've got this child being compliant pretty much all the way through the process in terms of probation and back in touch with their special ed teacher the day after the alleged violation was turned in. But somehow she gets failed by this system. And
Joe,
so you got all, yeah, go ahead.
Let me throw this at you and see if this changes anything, because I'm getting other details about it as well. The prosecutor and the social worker recommended a residential program for mental health and anger management. She was diagnosed with ADHD and a lot of what you said as well. But the judge overruled the prosecutor and the social worker and said that she was a threat to the community and said that she should be put in. Now, she was put in, I believe, earlier this week, and the next hearing date is September 8th. So you think about that. That's half of July. Sorry, she's been in since May. So that's June, July, August, how does that make sense for homework? I went to Catholic school. I thought they were tough.
And most people will tell you, my best friend is a teacher. My wife is a speech therapist, where people that get the therapy have to get on the system. They will all tell you that up to half, maybe at best, about half of the kids are dialing into the system and doing the things that they needed to do. Me saying dial in, that dates me. But most kids, this was not inconsistent, her level of participation with what you see from most kids. Now, if the child was not violent enough to be permanently incarcerated when the actual underlying issue occurred, which was biting the mom's finger, how is she now suddenly a threat because she didn't go to class? She's got ADHD. She's supposed to pay attention from home, and kids without ADHD aren't paying attention from home. This is what lets you know what kind of problem we have. And, you know, at the risk of being entirely too simple, this judge has looked at this Black girl and seen something that the people that value our lives and value second chances don't see. And that's why we have the problem that we have.
Yeah, I just want to end off before we go to break real quick. The judge said most people go through their entire youth without having the cops have to come to their house because they can't get themselves together. It's interesting how this judge looks at the role of children. I can tell you, I'm here at Law&Crime. I'm a defense attorney. I practice. I've been stopped and frisked in New York before, so how does that have any difference? I know many of my colleagues, we've never been arrested, but we've had many officers stop us and approach us. That's not an indication of us as human beings. I think it's more of an indication of the system at hand. We're going to come back with more after this break. So an officer has been arrested and charged for doing, get this, putting a gun to an unarmed man's head while handcuffed to demand his name. Now, there seemed to be some sort of error when an individual was transported from a jail facility to a behavioral facility, and he was released. Now, the officers approached him and arrested him, and because he would not give his name, a former Sergeant Amin believed that he had the right or the ability to put a gun to this person's head to demand that he give his name. I don't know where he learned this. I don't know where this sergeant believed that this was appropriate, but the Hillsbury Sheriff's Department thought that this was wrong, and they are pressing charges as such. Here's the presser talking about the firing as well as the charges that are coming up.
Yannick Amin, who clearly violated our mission and broke the law, was arrested earlier and is charged with aggravated assault with a deadly weapon. And his employment with the Hillsborough County Sheriff's Office has been terminated. Sergeant Amin's actions, the violation of public trust, and dishonoring of his oath to serve and protect is despicable. It's important to share with you that the complainants in this case are all fellow law enforcement officers. We encountered an African-American male suspected of leaving DACO Behavioral Health Center after he was inadvertently transported there from our detention facility. This individual was escorted to the ground after he was found hiding behind a trailer, taken into custody and being held in a prone position where deputies attempted to positively identify him. Initially, he refused to confirm his identity. He was not armed and made no aggressive actions towards our deputies. Sergeant Amin, who was kneeling next to the victim, pointed his firearm at the victim's head and threatened his life simply because he refused to identify himself. Deputies and another supervisor who were on scene intervened to de-escalate this situation and were eventually able to positively identify the subject.
So this is a personal point for me. I think that in covering stories like this, it's important to highlight, where officers are doing things that you want them to continue to do, and definitely come down hard on those who don't. In this story, there's a bit of both. There are officers who intervened when former Sergeant Amin held a gun to his head, saying, hey, we can identify him, we can identify him. I don't think they intervened enough because a gun was still put to his head, but there does seem to be some elements of intervention. Let's put that out there. But what this former sergeant did, Joe, I can't, like, why? How does that, what planet, I know it's not Earth, but what planet does this make sense?
You know, it's just amazing. So I guess you imagine yourself going through this scenario where maybe the cop is thinking, officers thinking, okay, they're not aggressive, they're not armed. Okay, you know, maybe he can live. But then he doesn't answer a cop's name. On my podcast, I just had a supervising public defender. And what he calls contempt of cop, when escalation can happen just when you are perceived as being non-compliant. So it might be not answering a question, like, you know, verifying your identity. It could also be not doing something that they tell you to do fast enough, which in a worst case scenario is a setup to allow for physical force. And so, you know, all these things go running through our head, and thank God for the de-escalation. They get credit for the de-escalation because maybe it made the difference between this person's life being saved or not. But it's just amazing how these officers think and how they're allowed to think. If you don't comply, whether or not the police officer ought to be asking what they're asking, it wasn't unreasonable to ask for his identity, but it was unreasonable to put a gun to his head because they didn't get it. You can draw more bees with honey. You're still supposed to protect and serve, maybe even from themselves, someone who you're questioning. And in this case, it would have been easier because this person wasn't violent, wasn't aggressive, and wasn't armed, but he still found himself almost being killed. It's absolutely unbelievable. But this is what, Brian, you and I could be dealing with driving down the street. We just had this discussion. This is why I wear, you know, a suit, driving my Acura in my town where I ran for city council, and I know people, because it can always go down just, you know, in a moment for next to nothing.
And I think, and I only say this because in my own personal experience, I come from a West Indian background, and I always remember hearing what my grandmother used to say, and I know that this probably goes from all different backgrounds of grandmothers. There was this concept of, it translated from Jamaican, if you don't listen, then you will feel. And I know that different backgrounds probably have something similar as well if you go back far enough when they used to bring out the ruler. But it seems like officers have a similar mindset of, if you don't listen, then you'll feel. And it's not limited to just when they feel in danger, when the other person has a weapon or shoots back. I understand that. But there's this mindset of, if you don't listen, then you're going to feel. And I think that's what this officer was going through of pulling out the gun. Again, topic we can go on for hours and hours, and I definitely want to, Joe, but we got to wrap up real quick. We've got one last story, that being a continuation of the Breonna Taylor case. Now, there's protesting that going on. It's over 116 days where no justice has been found. There have been no charges, nothing. The AG is saying that they are still investigating, still getting more information before they come to a conclusion. And so what a group of individuals did was march down to the AG's personal home and decided to sit in protest, screaming out, as you can see there, sitting down and standing as well. And by all accounts, this was very nonviolent. They were sitting, saying, "Say her name." And again, officers came up, said, hey, you need to leave. Those who chose to leave left, and from my understanding, were not arrested. Those who chose to stay, about 87 of them, were arrested for what makes sense, trespassing, but one charge of intimidating an individual who's participating in a legal process, which would be the felony, a D felony in Kentucky. That's the charge that really had me scratching my head. Before we get into the details of that, Joe, what did you think about this protest, about sitting out on the AG's lawn, and about how it unfolded?
Well, protest is going to be protest. It arises out of a deeply held frustration that there's been wrong done in this Breonna Taylor situation, and there's no justice. We haven't even gotten on the road to justice. So apparently, a lot of folks peacefully protested.
Joe, one second. Sorry to cut you off. Let's quickly show. Let's show the clip of them protesting, and then let's talk about it.
Cool.
And so, Joe, so that's the clip, and I want to add in the legal part real quick. Intimidating a participant for the legal process, a person is guilty of doing such when, in part of that protest or part of that action, they use physical force or a threat directed to a person. I didn't see physical force or a threat there. I saw chanting. Right, exactly. You didn't see physical force or a threat, but what you do see is a felony charge for protesting. So there's a lot of people that will be less sympathetic and say, well, you know, they get what they get because they were protesting on someone's lawn and personal space. The Kentucky AG had an opportunity here. Bad enough you don't have the goodwill that's put in the ground from the police doing the right thing. My dad used to always say something, you can look to the corner, but I'd rather you look around it. So looking around the corner, what do we see? We've got a situation where now they're trying to enforce law and order without there being justice. So you give people sitting on your lawn a felony, you overcharge them because they're protesting, which they actually have a constitutional right to do. We understand they don't have a constitutional right to do it on someone's lawn, and there is a reckoning for that, and that's what's being done. But again, you have a situation where people want to have their own definitions of law and order starting in the middle of the story. Agree. And you're not going to get anything done that way. Yeah, and they got it done. We got Bob Bianchi coming up next for Keeping the Peace. Bob, what do you got for us?
Execution bonanza, Brian. The government, after 17 years, is now going for the 3rd or 5th death penalty sentence in the next couple of days. Gotcha, Bob. We'll be back with more Justice and Peace tomorrow. I'll see you then.